Okay, can we start with a beautiful prayer?
Of course.
God bless me, God bless me always. I am your little baby, please protect me. You are my papa, you are my mama, you are my world as well. Help me always with your invisible hands. I can see you in a rainbow, I can see you in wind. I can't touch you, but I feel you always in my life. God bless me, God bless me always. I am your little baby, please protect me. Thank you all.
Thank you, Rana.
Yes, can we start? It's my duty for welcoming all. I extend my warm welcome to all of you to this wonderful webinar that is before and after Pocso. Protection of Children from Sexual Offences Act 2012. It is very relevant topic in present days. I'm welcoming our chief guest, that is Advocate Robin Raju, this BA LLB in Delhi High Court. I would like to say some words about him. He is none other than he was born and brought up in Delhi. He did his schooling from St. Columba School, New Delhi. Then did his graduation in political science from Deshbandhu College, Delhi University. Then thereafter did LLB from Campus Law Center, Delhi University in 2012. During his college days, he was part of various extracurricular activities that he has experience of law practice in diverse parts of law and both civil and criminal law. And he had worked with seniors who practiced in Supreme Court. And at present, he is doing his independent practice in Delhi. Welcome, sir. Welcome, Swambina.
Thank you, ma'am. Thank you for the welcome.
Thank you. Next, I would like to welcome our senior faculties, that is Rahmat ma'am, Vanisha ma'am, Smita ma'am, Shiba ma'am. And next, I extend my warm welcome to our junior faculties, my colleagues, Premila ma'am, Lekha ma'am, Aditi ma'am, and Shishna ma'am to this wonderful webinar. And last, not least, I would like to welcome all the participants to this webinar. I hope you have a wonderful session with us. Thank you.
Thank you, Rana ma'am. Yes, I think now we can welcome our Robin Raju sir for taking up the section without wasting time. Yes. We are not taking much time for introducing or doing other things. We will go straight with our topics. Robin Raju sir.
Okay, ma'am. Okay. Thank you. Thank you for the welcome, Renu ma'am. All the faculties, all the participants. Glad to be part of this webinar. It's a topic which is very pertinent, which is very important topic, which as teachers we all need to know, especially as to what are the rights which are there for children, and especially about this particular law, which is basically child-centric. It is not. It is unlike all the other laws that are there, and this is a law which was always in demand. Finally, in 2012, this legislation was passed, and the need of the law. So I'll be talking about that. Why there was a need of this law, and what is the change that has happened after this law has been passed. So it's basically in two parts, and then I'll also delve into the challenges that are there, the road ahead. So that's how I'll be talking about this. So just to give a brief introduction before I start my presentation. If you look, before Pocso came into being, before Pocso was passed, there was a situation in the country where there was offenses were committed against children. Sexual offenses were committed against children, but there was no specific law. So all the offenses were covered under Section 375, 376, 377, as well as Section 354 of the Indian Penal Code. So everything was under only one main statute, which is there, which has been there right since the time of Britishers, 1860. So that act was there. So there was a big need that laws which are specifically, which is catering to the need of children, is passed. And there were a lot of events which have happened post independence. The judiciary had to face a lot of cases where they had to come across incidents where children were, sexual violence was committed, sexual offenses were committed against children. And what I will be also, I'll try to focus on some cases which were like
Zebronics for life.
Of that time before Pocso came or legislation was passed. And subsequently, I'll talk about the relevance of Pocso and what Pocso has the changes that it has brought. So I will like to show the slides. It's just a small PPT. It's not covering everything. Side by side, I'll be explaining it. So can I go to the?
Yes, sir. You are allowed. Yes.
I share screen. 1 second. Can you all see, ma'am?
Yes, sir. Yes.
Okay. So this is before and after Pocso Act. The introduction. As I said, this act came into force in the year 2012, and it deals basically with sexual abuse of children. It is also very important to keep in mind is that this is a gender neutral act. So it doesn't discriminate in terms like that it is only for women, only for girls. It is also for boys. Everybody is covered under this act. And this act deals with varied offenses. A lot of kind of offenses are covered under this act, which includes child sexual abuse, as well as pornography. Child pornography is also covered under this act. Now, coming to the important first part of my presentation, before Pocso Act. Now, if you look at it, before Pocso, as I said, there was only IPC which was there. Indian Penal Code was there. There was all the offenses which were committed on children were tried, or the trial was done under, the charges were also under the IPC 375, 376, 377, as well as, especially if it's against boys, then it was 377. Section 377 talks about unnatural offense, unnatural sex, and so it is about that. The section 354 is about hurting the modesty of women. So these were four main provisions which were there, under which a crime, a sexual offense was basically, charges were put on. Now the offenses did not cover the varied type of offenses which are there and which children were facing. So therefore there was a need for an act, which the UN cry was also made about it. Now we'll come to pre-Pocso era. What was the scenario? Now, as I said to you in the introduction, there were a lot of cases that came before the court before Pocso was passed. I am focusing on some cases which are there. Now, these are the cases where the courts actually took an out-of-the-box view about this kind of crime that is happening. So in 1956, way back, just after we were independent, there was a case that came before the Orissa High Court. Now, in that case, the teacher was the accused. Now, the High Court at that time sentenced the accused, gave a sentence and increased the sentence rather to 7 years, and also made directed to pay compensation. So that was something of a landmark path-breaking kind of judgment at that point of time by the Honorable Orissa High Court. Then 1972, straight jumping from that, Gurcharan Singh versus State of Haryana. There was another case where a minor victim's testimony, the aspect of a minor victim's testimony was considered, and it was said that how a friendly atmosphere must be created so that when a child is giving his testimony before the court, they can do so, they're able to do so without fear. Then comes a very important case, which is a kind of a black spot also on our judiciary, which is a Mathura rape case. I don't know whether you must have heard of it. I hope this is a case which is in the limelight at that point of time, and even today people do search about it. Mathura rape case was a case of custodial rape, where a young girl, a minor around 16 to 18 years, she was raped in police custody. Now, this case was one where the trial court had convicted the accused, but then the High Court, the Supreme Court, actually, which is very important, is that the convicts, they were acquitted. The accused were acquitted. So by acquit means, as you know, that the charges against them were they were discharged from the charges of rape. Now, at that point of time, there was a lot of hue and cry why this has happened. So the court at that point of time, 3 judges bench, which decided it, they considered that the girl at that time, the relatives were outside the police station, so it was not out of fear, and she has given consent in a way. There were no marks on her. There were no body marks, so there was no. There seems to be no kind of force which was there. So all of those aspects were considered, and then the accused were acquitted. Now, this case, actually, there was a lot of hue and cry. There were academicians and people, feminist organizations. Actually, after this case, organizations such as Saheli, the NGO, also was formed. So you can see that there was a lot of hue and cry. There was a lot of criticism about this judgment in the public domain. And after that, there was a second amendment which was brought in the criminal law. And as a result of that amendment, there was in the Evidence Act, in the Indian Evidence Act, there was an amendment which was made, which said that there will be a presumption that once an accused gives a statement, once a victim gives a statement, then it is deemed that the person has committed the crime. So there will be a presumption against the accused, presumption that he has committed the crime if the victim gives a statement. So this happened because of this incident, particularly because of this case. Then when we go again further, we'll see a few more cases. See, there are lots of cases, but I'm just covering a few important cases that I felt should be shared with all of you. Another case was where Harpal Singh was the state of Himachal Pradesh. This was Supreme Court in this case had condoned the delay, forgiven the delay that happened in filing the case of a rape of a 16-year-old girl. So usually we know that when an FIR is advised, that FIR should be made at the earliest, a complaint should be given at the earliest to the police. But then there was a delay in this case, but considering the fact that it was a minor and a rape victim, so the delay was condoned. Then we come to another case, Sheila Barse versus Union of India. This is a very interesting case. This Sheila Barse is a madam. She's a child activist, and she is somebody who was fighting for the rights of children. And this particular case was about some 16 juveniles who were there, and how their trial was getting delayed. And eventually, in this case, the court said that right to trial is a fundamental right. Right to speedy trial is a constitutional right, is a fundamental right. It's implicit under Article 21 of the Constitution. I'm sure all of you know Article 21. It's a very, very important constitution, which a provision of the Constitution, which gives protection of right to life and liberty, unless it is, if there is through a procedure established by law, then it can be curtailed. Otherwise, the right to life and liberty is protected by this particular provision. Then Sudesh Thakur versus KCJ and others. This was a very shocking case, 1996 Delhi High Court case. And in this particular case, it is a case where a father is involved and he uses his fiduciary, he uses the trust, misuses the trust of and sexually abuses his daughter. So this was a case where High Court then looked at it and said that there is a need, for the first time, there was a need to elaborate and expand the meaning, the term of rape and penetration, another word which is there. So they said that there is a need to elaborate the terms such as this, and higher punishment should also be given to sexual offenders who hold a position of trust and authority. So, like as I said, in this particular case, the father and the daughter, they are in the father-daughter relationship. So, sacrosanct, very sacred relationship. This and the father misuses the trust of and the authority that he had on his child. So therefore, the court said, even before Pocso came, legislation came, you can just imagine, the courts took a very serious view of this issue. And they said that higher punishment should be given in such cases. Then comes the case Sakshi versus Union of India. This is a 2004 case. Now, in this particular case, the Supreme Court looks into the matter completely and also says that formulate certain guidelines, which are known as Sakshi guidelines. Now, these guidelines basically talk about how a child victim should be kept away from the accused, number one, which is very, very important. When a testimony is being done or when a child's statement is being recorded, he or she should be given a very safe atmosphere. They should not be in the presence of the accused. Number two, the victims of the child abuse, while giving testimony, they should be given breaks. They should be allowed breaks when they are making a statement. So the whole idea was of formulating these guidelines was that the children-centric or children-friendly atmosphere should be there. When a case concerning a child, a case of sexual abuse against a child is being tried, is a trial of that, a case of that nature is going on. Now that kind of brings me to the end of the first part. So as you can see, the number of cases that I have pointed out, see, there are lots more cases. So what one needs to understand is that even before Pocso, this legislation was passed, the gravity of this offense, the seriousness of this offense was considered by the courts of law, even though they did not have a law before them in their hands to adjudicate the cases. They only had the Indian Penal Code, and on the basis of that, they had to adjudicate. They had to the trial had to be done. The charges were framed on what the IPC said, but still the facts were considered in totality, and they came to the conclusion that these kind of offenses were increasing. And I have to say that the NGOs as well as the courts of law have played a very important role in bringing this kind of a legislation. It led to this legislation, this very landmark act called as the Pocso Act. So this is the first part of it. Now coming to the second aspect, what is this act talking about? The Pocso Act that we're saying, Prevention of Children from Sexual Offences Act 2012. Now this is an act which basically has enhanced the scope of offences against children. So as Yada told you, there are lots of offences which are there, which were not even thought of earlier. But this act covers them. As I said, child pornography, even a kind of harassment that the child has to go, where somebody is following a child without their consent, they're using their photos and they are misusing it in a way against which is against the interest of the child. And in that way, so the lots of offences which one might think that these are very minor offences. But still, even those minor offences, which one might think are also being covered under this Pocso Act. Now, what does it say? Section 3 of this Act basically talks about aggravated penetrative sexual assault. Now, this is very important. And Section 5 also deals with it. So, why I'm specifically talking about certain sections? Because, see, the most important thing that we need to understand in this Act is that this Act basically is very stringent, very strict against those people who have committed crimes against children by misusing their fiduciary or misusing their trust that the child had on them. If they have misused their trust, like for example, a blood relationship, a father a school teacher, principal, somebody who's working in a maybe in a hospital or doctor, or somebody like that who's there, and the child has trust in that person, and then they misuse that trust, and then the act is committed. So this act is very particular, very strict on them. Now there is a lengthy provision from A to P which is there in section 5, and it deals with, so when you just Google search, you will get the act also in the entirety. So that's why I'm not going too much of details in it. And it deals with situations which come within the ambit. What are the situations which are there? So as I said, these are the situations, like if as well as police custody, somebody, for example, a person in uniform, as well as an army man, an armed forces person, whoever it is there, whoever gives an impression to the child and who's in a position of dominant position and position of higher authority and trust, who builds trust in the child and then he misuses it, they are all covered under this particular act and under these certain specific provisions like section 5. Now, sexual assault is an offense under Pocso. Now, this is something which you also need to know. Section 7, sexual assault is an offense under Pocso. Now, sexual assault as such is defined in a very broad way. So even today, you know that these days a term called bad touch, good touch is also taught to children. If somebody is touching you, what kind of touch is a good touch? What is a bad touch? So somebody is touching somebody's the child's private parts, or tells the child to touch their private parts. So that comes within the ambit of these kind of sexual offenses against the child, a sexual assault category. Or for that matter, as I said, penetration, the word penetration, the ambit of the word has increased. So it is earlier, one used to think that it is only a penile or vaginal penetration which is there, but that is not just that. Any kind of object is put in or in the private part, or for that matter, if kind of anything which is against a desire, if the child has been, the body has been misused by somebody, has been trying to touch it, as I said, bad touch. So these things will come under offenses under this act, as well as the definition of penetration as also in the sense what I said earlier, in that way it has been widened as well. Now the punishment sections also. So there are different gradations. So the punishment which is for sexual assault is little less because it only talks about certain touches that which comes under sexual assault, which has been done by somebody against a child. So those kind of offenses, like 3 years will be the minimum punishment. But when we talk about aggravated penetrative kind of the offenses that come under that, aggravated penetrative sexual assault. So those kind of where penetration has been happened. So those obviously will have more of punishment. The punishment will be much more. Now aggravated. Now that you need to also understand that this particular act has divided the offenses into two types. Like one is normal, like sexual assault, for example, and then it has defined it into aggravated, which is in a more severe way. So the punishment obviously will be more when it is an aggravated kind of an harassment or an aggravated assault. Now in the section 9, aggravated sexual assault. Now it covers situations again where, like section 5, as I said in section 5, where we talked about aggravated penetrative assault. In the same way, aggravated sexual assault is also when it covers a situation where somebody is misusing their position, the authority that they have. They are misusing their dominant position and they commit a sexual assault on a child. So that again is covered under this particular section, section 9. And the punishment will be not less than 5 years, which may extend up to 7 years, which is not less than 5 years is the punishment which is there for aggravated sexual assault. Now, sexual harassment is also another offense that is there under this Pocso Act, section 10. Now, when a person with sexual intent, now this is very important, sexual intent, the word sexual intent. So when somebody with that intention utters a word, makes a gesture, like says something, follows or makes some movements, tries to show their body to the child, naked body or anything of that kind, that will all come under the ambit of sexual harassment. the child complains it to the parents should have a duty bound, or anybody else who's informed of such an offense, which I'll come later on. So they have a duty to report it to the police, and then immediately this act gets covered under sexual harassment. So you can imagine it is such the ambit, the whole purview of this act is so wide. The offenses, there are many offenses that are covered which we not even thought that could get covered under this act. So makes a child, as I said, makes a child exhibit his body, or then importantly shows pornographic material. So if there is a pornography in which is there in a particular person's phone and he shows it to a child, that is wrong. That is an offense under Pocso. And also even I think I'm coming there. I do touch that in the subsequent slide, but I'm saying this here again. Pornographic material, even if you're storing it or keeping with you, which has a child in that, which involves a child, then that again is an offense. Now this is something which is very, very important to note. Many people are not aware of that. So even if you're keeping something, and if that is proved that it is for transmitting or propagating, you want to show it further, you want to spread it further, then that is an offense, mind you. And the offense and the punishment increases when it gets proved, or when the charges are that it was for commercial purpose, it was to sell it in the market or something. Then the punishment will increase. Now, continuing here to that point where I left, watch pornographic materials. Then thereafter, even if you see, if somebody is following a child, constantly following, watching a child, tries to contact a child, either directly or through some electronic means, or tries to threaten by using a form of media, says that, look, I have this picture of yours with me, I will misuse it, so you have to succumb, you have to fall into my devious plan, and tries to blackmail a child or something like that, then all of that will get covered under the Pocso Act. So therefore, it is very, very essential that how these people who misbehave with children and who have this criminal intent, who have this sexual intent in their mind, they really need to be aware that this act is very, very strict. Punishment up to 3 years of imprisonment. Now, sexual harassment cases, the punishment is up to 3 years in this particular case. Now, as I said earlier, now this point comes again. Storing, I'm reiterating it because it's very important, because this is something which we generally think it's a minor thing. What is it? If somebody is keeping that in their phone, or they're using that material, if it gets caught, or if their complaint goes against it, it can cause problems, mind you. And especially if it's proved that he was propagating it, he was spreading it to others, he was sending that visual to others, or using that material and spreading it to further more people, then it means transmitting or propagating, and therefore it is a big offense against, because you're doing against a child, and the punishment is not less than 5 years. So you can see these are kind of offenses which were earlier not even, they were heard. There were a lot of offenses that were happening. The Ministry of Women and Child Development, actually in 2007, if I'm not wrong, they had a data also stating that how approximately 57-58% increase was there in crimes against children at that point of time, 2007. And therefore, this issue was become very serious. And at that point of time, I just want to tell you, for your knowledge sake, that there was no state which had a specific act except for Goa. Goa had an act towards children, but other than that, there was no act also which was available. So therefore, there was this growing demand, especially among NGOs which were working for child welfare, that an act which is very strong and which is child-centric should be passed. Now, if the objective, as I said earlier, if the objective is for commercial purpose, like if the pornographic material, somebody is using it for commercial purpose, they're spreading it, and they are trying to his objective is to earn money from it, then the punishment is more strict, is stricter. 3 years of punishment is there for that offense. Now, some more key points that we need to know here is Section 19, duty to report offenses. As I said, everybody has a duty to report such kind of offenses to the police. Now, if we get to know that there is some crime of this kind, if there is some offense that has been committed against a child, And it is not just merely a rape that we are talking about. It's not just merely a penetration that we are talking about, an aggravated penetration, which are obviously very serious offenses. But even cases, as I said, of a bad touch, even cases of somebody misusing a child's photograph and morphing it and spreading it across, or using pornographic materials which consist of children, or sexual assault, which is, as I told, is about showing themselves that their bodies to exhibiting their body for a child, or for that matter, following a child, disturbing a child against their wish constantly. So these are all offenses which will come under the ambit of Pocso. And if we come to know about it, then we are duty bound to inform it to the special. There should be a juvenile police unit in every police station. Now, if there is not there, then inform to the local police station, wherever it is, that such an act has happened. Or maybe, or you can call it to the child helpline number 1098. You can call and then inform them that there is something like this which has happened. Now, obligation on media, photographic facilities and studios to report cases. Now, this is also another, specifically the act talks about this, that if media persons of a matter, if somewhere like, for example, in a hotel or in a facility where there is studios which are there, and if they find that there is some kind of material which is there, if the owner finds that one of its staff is keeping a material in their system, or they have that with them, then this owner will also be liable, can be held liable if he doesn't report this offense. So therefore, it is very important that the owners also don't put these kind of offenses under the carpet, and they inform to the authorities, they inform to the police that such and such video or such and such material is there, and it needs, and then they should inform it to the police that it has been stored by someone, they're keeping it with them, and they're constantly using it and misusing and spreading. If it is that is the case, then it should be informed instead of just keeping it hidden. Then failure to report. So as you can see, if you don't report it, if you don't furnish the information to the police, then there is a punishment up to 6 months under this act. False complaints shall be punished. Now, this is section 22 talks about false complaints. So if somebody, mind you, if the person is a minor, then there is no action taken. If it's a child who's made a false complaint on somebody, but apart from that, any person who's above 18, he gives a false complaint against somebody that so and so has committed a crime against under Pocso, and if it turns out to be false, then it is false complaints shall be punished. So it's important that we don't give false complaints. Prohibition on media from disclosure of identity. This is very important. I think this few people all must have come across. There are a lot of in the recent past, there are a lot of news regarding this that has come up. Like sometimes politicians or celebrities, and when they suddenly in their social media account or somewhere they name the person, they name the victim. That is wrong. You're not supposed to disclose the identity of a child. Also, no person shall make any report or present comments on a child without having complete information. So it's important. Even if I sit and make a post, write a big huge post on social media and comment on that, like, look, so and so an act has happened, this that, merely on hearsay. I don't even know whether it is true, and I just heard somewhere and I do that, and it turns out to be false. I will be under liability, and I can get into trouble. So therefore, it's important that we don't spread unless and until we are sure about it, that there is something like this has happened. And it is important that we don't disclose the identity, especially it's media. There is a clear prohibition on media from disclosure of identity of the child. Now, duty on the police. Now, this is also something which we as citizens should know. Not just that, we should be aware that what are the duties that the police have when they deal with such kind of offenses. Now, the police, while recording the statements of a child, should record at his residence or his place of choice. They are not supposed to tell the child to come to the police station. They cannot do that. Under the Pocso Act, the police should be facilitating. They should be as cooperative as they can. They should consider what is the child's opinion, what is comfortable for the child, and there they should go, either to his residence or his place of choice. the officer should not be in uniform. So when an officer comes to take the statement of a child, they should never come wearing their uniform. They should be in civil dress. Because when they come, obviously, you know that, because a child will have that fear. Okay, an officer, police wala has come and he is taking their statement. The level of fear automatically will come in the child's mind. And the child can panic and can lose their mental balance and all of that. Child should not come in contact with the accused. This is a very important thing. The police should ensure that nowhere, even there is a duty on the magistrate also to ensure that during the trial, the child is not in contact with the accused. And therefore, there should be a compartment which should be there before the child and the accused, so that the child is not seeing the accused. For example, for a situation where both the child and accused have to be presented in the court on the same day, then they should not be made to see each other when they are making their testimonies. Identity of the child should be protected from media. Again, as I said, the identity aspect is given a lot of importance in this act. The child's identity should not be, at any cost, should not be disclosed unless and until if the police gets a special permission from the magistrate. If they get a permission, okay, this is in the interest of the child, you can disclose the identity, then they may do it. But otherwise, they're not supposed to do it. Child should not be detained in police station at night. At night, the child should not be kept at the station. If suppose the child has gone there, police anyways should not call the child there at the police while taking in a statement or otherwise also. And but if they go there, they are not supposed to be kept till night, detained for the night. Now coming to the next important part, which is medical examination. Now, for example, a victim comes to the police. A complaint is made up that she or he has been sexually abused. Now, what should be done? An examination has to be done. There is an injury, for example. So then examination has to be done. Medical examination is a must. Now, in that case, in the case of victim is a girl child, then the medical examination should be conducted by a woman doctor. It has to be conducted by a woman doctor. It's mandatory if it's a case of a girl child. The medical examination shall be conducted in the presence of the parent. Again, very important. The parent should be there, or if the parent is not there, then any other person on whom the child, guardian, for example, on whom the child reposes trust or the child has confidence, that person should be there. The medical examination shall be conducted in the presence of a woman nominated by the head of the medical institution. Parent is not there. So if the parent is not there, then the medical examination shall be done. It has to be done. But the presence of a woman nominated by the medical institution can nominate somebody, but it should be a lady, as I said. So this is about medical examination. Broad points, which is connected with medical examination of a child. Now, some more important points, which is very worth noting. Now, as per this act, what I want to tell all of you is that there is a provision which says that there should be special courts which should be constituted to try to deal with such kind of cases. Special courts should be there. Pocso courts should be there. Now, this is the reason being that speedy trial, as we have said, it's part of our fundamental rights, because Article 21 has been broadened by the Honorable Supreme Court, and it includes right to speedy trial. So therefore, especially in these kind of cases, now you know that even women, the rape cases also, they have fast track courts. So the fast track court, the objective is that trial should be conducted in a speedy manner. So there has to be a special court. A court should be designated for each district to try Pocso related cases. Presumption that a person who's being prosecuted has committed the offense unless the contrary is true. Now, this is something which is important. There's already a presumption which is there in the Indian Evidence Act, which I had said after the Mathura rape case, the Second Amendment was also passed. Now, in this particular act also, there is a presumption that if an allegation has been made against XYZ, that he is the accused, he has committed a sexual abuse, he has committed a sexual offense against a child, then the court will presume that he has committed that crime unless and until the accused proves that it is contrary, that it is not the case. So presumption will be that he's committed that crime. There is also a presumption of culpable mental state. Culpable means a person has done it with a guilty mindset. He has done it with an intention, malified intention. So that intention also will be presumed when a child related offense comes before the court, when it comes within the ambit of Pocso. So mind you, the accused is always at the ball. He's pushed to the wall. He's at the back foot. And that is why this is a very, very difficult act. Once you are trapped under Pocso, it is very difficult to come out of it. And that is why the accused, they don't get bail also easily. They don't, it is very, very difficult in these kind of cases, especially with like the heinous kind of cases which are there under the Pocso Act. So therefore, because of presumptions are also against the person, against whom the allegations have been made. Because the court will presume that the person had the intention to commit the offense. Section 33 deals with procedures and powers of special court. Now, this is an act which deals with, as I said, now in this particular provision, there are provisions which basically these are provisions deals with what a magistrate should do. The magistrate, once the police gets in information. Now I'll need to elaborate this a little bit. See, I'm not talking about Pocso rules in this, but I would like to touch that now. Pocso rules. So every act will also have certain rules. The state can amend the act and they can also add rules into it. And those rules basically consist of procedures which the court or which the police should follow in these cases. Now, as per the Pocso rules, what happens is, like when there is a complaint a child has made, for example, and he tells a boy or girl goes and tells a parent that, look, somebody has done this to her, touched badly, or has done an offense, a sexual abuse she has faced, or he has faced a sexual abuse. Now, what does a parent do? The parent immediately must report it to the special police juvenile unit, which is there in every police station. It is mandatory that should be a juvenile unit for children, but unfortunately, there are many police stations where there is no cadre like that. There is no special team which deals with child-related offences. Then what police officer, whoever is the police officer, should be informed. That's number one. Now, once the police officer has been informed about it, the police officer needs to do a preliminary inquiry and they immediately register the FIR. Once the FIR has been registered, then this normal procedure is that, as I said, the testimonies, when the testimonies have been done, testimonies have been taken, it should be done in a very child-safe manner. The police should go to the child, whichever place the child is comfortable. They should not go in their uniform. All of that, which I've already touched, I don't want to come back to those points. They should be doing that. At the same time, there's a Child Welfare Committee, CWC. The CWC should also be informed about that there is this offense that has been registered. The police officer should maintain a diary. He should maintain in the diary the offense, the details, everything should be there. And he's not supposed to disclose it, but he should maintain the diary, which should have all the details of the accused, the nature of offense and everything. Now, there are certain scenarios where the near and dear ones, for example, the father or somebody of a blood relationship who's staying within the family has committed the offense. Now, in that scenario, when a child makes a complaint to the police officer should then inform to the Child Welfare Committee about that there is an offense like this that has happened. The Child Welfare Committee then will look into this matter, and what they're supposed to do is that they will hold an inquiry, and within 3 days, the police officer has to inform within 24 hours to the Child Welfare Committee. And within 3 days of working, the Child Welfare Committee will institute an inquiry, and then they will decide whether or not the child should be moved from that house and should be separated somewhere in a protection home or an observation home or wherever it is, in a separate place where the child is safe. So that is something that the Child Welfare Committee has to take a decision on. So therefore, the Child Welfare Committee, which is formed under the Juvenile Justice Act 2015, they play a very, very important role in this particular Pocso Act. So this is something which we need to understand. And also, in each district also, there is a child protection unit that should be formed, a child welfare team, DCPU, which should be there. That's also which is stipulated. So I hope you understood about this aspect that I'm trying to say, the procedures and powers. So there is duty on the police, which I've already touched upon, and there is duty on the magistrate as well as to ensure that the child is getting, number one, proper legal representation. They are not deprived of a legal aid. Number two, the child can also, if they should be assisted by giving them a child support. For example, the parents are not very well versed, they're not educated, they don't know the procedures and things like that. So the child welfare committee understands the scenario and then they will give them a support. So that also the child will get. A translator, a counselor, or expert. So these are people whom the child can get the support of. There are specifically these names are mentioned. So in such scenarios, when a crime of this nature is committed, the support of these people will be there for the child, for the victim, will get the support from these people. Expert support will be there, and the child welfare committee will ensure that they get it. If the child is in need or the circumstances prove or show rather that a child requires that support. Section 33 deals with procedures and powers of special court, which I've just said that about that. So these are the powers which are there, unlike the other offenses. And also, it's herein I need to also mention that speedy trial is essential as per an essential factor or an essential point when you look at this act. So it says that the magistrate should try to end or should try to finish the investigation within 1 year from the date an offense has been brought to his cognizance. So the maximum period for completion of the investigation, the completion of the trial, is conclusion of the case is 1 year. But it's not. The act also says that as far as possible. But we see that. But we see that that doesn't happen at times because this goes on more than 1 year. Sometimes it takes on a lot of time and it goes beyond 1 year. So it doesn't happen like that. But though they have mentioned that it should be 1 year. And the testimony of the child should be recorded within 30 days. So that is also something, because the child should not be constantly harassed and called all the time. The police should not constantly come there and always take in the name of recording statements. So it should be done as quickly within 30 days maximum. The offense is committed by a child, then the offender will be dealt under the provisions of Juvenile Justice Act. So if in the case where the offender, where the person who is accused is a minor himself, then in that case that accused will be dealt under the Juvenile Justice Act 2015. As I said, the special court should try to complete the trial within 1 year from the date of taking cognizance of the issue. So within 1 year, the trial should be completed, should not get extended beyond that. Sections 3 to 13 will, this is important, section 3 to 13, which we have all talked about penetrative sexual assault, about sexual assault, sexual harassment, all those offenses that we have talked of from section 3 to 13, they deal with varied offenses, child pornography, things like that, specific offenses that I've mentioned. Now, those offenses, those sections rather, will not be applicable in a case where medical examination or medical treatment was being done, undertaken with the consent of the parent. So, for example, if a parent has taken a child to a doctor, they have given the consent to the doctor that they want this child to be treated. For example, something related to reproductive treatment or sexual reproductive, or some kind of a surgery that has to be done. In that case, then later on you cannot make an allegation that look that there was some kind of penetration or something has been there's this kind of sexual abuse that has happened, because the consent was given by the parent for the treatment to the doctor and to the hospital. In that case, then it is exempted. In that case, it doesn't fall within the ambit of Pocso. So this is about the important points that are worth noting. Now, before I come to the last slide, which is the conclusion, I just want to also talk a little about the recent scenario that we need to see. See, there is something that which I have not mentioned in the slide, is that we've all heard about the Kathua rape case, right? We have all heard, right? Kathua rape case. Kathua rape case this happened in Jammu and Kashmir. where this little 8-year-old girl, I suppose, was raped, brutally raped, killed. Now, this incident shocked the conscience of the nation. Now, after that, there's an amendment which was brought in the Pocso Act. What is this amendment? This amendment says that capital punishment can be now given under Pocso Act. So therefore, you can imagine the only thing which was left was a capital punishment. Even that can now be given, because life imprisonment, as you know, has been defined that it is imprisonment up to one's natural life, or till one's death. It can extend to that period. So then you have also capital punishment here. Capital punishment can also now be given. So amendments are being brought about in this act, and in order to make it more stringent, as far as stringent as possible, that is what we are seeing now. Now, coming to the conclusion which is there, the Pocso Act, if you see, is indeed a path-breaking act, which has definitely given a message to the public at large that state sees sexual offences committed on children very seriously. As I said in the initially also in my introduction, that this act has given a strong message. The intention, that's how the state perceives, how the state sees these kind of offences. The state sees it as very, very serious, grave, and therefore this is the act that is there. And we have recently seen one of the judgments. I've not gone into the post-Pocso landmark judgments, but there is one judgment that I want to talk of, is about that Kerala High Court recently, in the month of September in 2020, during this pandemic, gave a judgment. This judgment talks about, it's a Pocso related case, Bhanu versus State of Kerala. Now, in this particular case, the judge said that every state, like not every state, like the direction was, particularly because of the reference to Kerala, he said that there should be nodal officers who should be there. And the nodal officer should assist the victims. He should also assist the courts and government and all the stakeholders. So the government should appoint a nodal officer who will be there in every district, who will be there in every earmarked place, and they should be helping the victims and the families and all the other stakeholders who are concerned with this particular act, as well as the offences related to it. That's number one. Number two point, which very importantly, which was said, that one-stop support center. This judgment also says that the state should make a attempt, should rather not just attempt, but should create one-stop centers, support centers, where people don't have to run behind police stations when there is a crime which has been committed under Pocso. They can straight away go to that one-stop support center, give their complaint, and then they can and that one support center should support and deal with the issues and help the victim and the family. That is what it said. Then there was also another thing which is importantly, which this judgment said, was that the police force should have a cadre. A child protection officers should be there. A cadre, a separate cadre in each police station, in the police force should be there, which deals with these kinds of child-related issues, child-related offences. And then when they are transferred, also they get transferred to the officers who are trained, well-trained officers should be there, who are able to deal with these kind of offences, and they should be transferred to the same cadre, and so that will help in dealing with these kind of offences, because these are offences which really need mind needs to be trained on how to deal with a child who's a victim, and also he or she is a minor. That also needs to be considered. So therefore, it is very important to deal with them very, very sensitively, and there should be trained officers for it. But we don't know how this is going to happen, whether the implementation, at the end of the day, it's for the state to implement now. But this is one judgment that just suddenly came to my mind, and I thought I should share with all of you. Now, what are the challenges that are there concerning this act? So no act is perfect, as you know. There are some gray areas. There will be some areas, loopholes, which will be there, and that needs to be covered up. As far as this act is concerned, what we need to understand is that the even after this act was this legislation was passed, this act was enforced, what we are seeing is that the rate of pendency of cases is very high. Cases are not getting disposed as quickly as one hoped for. There are various factors for that. You can't just say that it is the system that is wrong, because there are times the victims, they don't cooperate, at times they're accused, then they don't appear, and uh, there can be situations like that. They are not nabbed, the police doesn't get hold of them, and there are situations like that. So, and the trial gets delayed. But what we need to understand is that the pendency also shows to the fact that ever since this legislation was passed, we are seeing that people are becoming more and more aware about reporting these kind of offenses to the police. And that is the reason why you're seeing such a high number of such a big percentage being reported before the police. Because people are coming forward now reporting. Earlier, they used to just put it under the carpet. Parents in themselves, they used to think that, okay, now who will run behind all this? Police, the child will have to suffer. They will be asked questions which will be uncomfortable, and the child will rather go into further depression and things like that. So their parents used to generally, and then also in the scenario where somebody close to the family is the accused, then their family would further think that, okay, we are not going and pursuing this case, and injustice would have happened, and the victim, the poor girl or the boy, would never get justice. But now we are seeing that cases are increasing. That means people are coming and using this act. I've understood about this act. But still, the drawback is that conviction rate is less, so the conviction rate has to be increased. And for that can only be done if the speedy trial is done. Trial cannot go slow. And that the act does say that within 1 year, trial should be completed. But as far as possible, it says as far as possible. It's not mandatory also. The other thing is that there are many other offenses which are not under the ambit of, though it is the Pocso Act has widened the scope of the sexual offenses which are there. It has a lot of sexual offenses are part of Pocso now, but there are still certain offenses which are not part of the ambit of Pocso. Cyberbullying, for example, or the sexual exploitation done through online means. Like these days, you know that during the pandemic, everything is online. So children are before the system online. We sometimes never know. They might get blackmailed or something like that happens, and through online code something happens, some kind of thing which happens. So the act is not very specific with respect to that. So those things need to be now a bit more clarity has to be brought in terms of in the act. These kind of offenses should be brought about, should be included. The other gray area which I've not mentioned in this is about what happens in the case where a girl and a boy who are about 16 to 18, between that age and adolescent age, and if they're having a consensual sex. Now, in that scenario, one of the parents or somebody concerned goes and complains against the boy, and then he gets he is charged under the Pocso Act, and his life gets into trouble, though it was a consensual act. But then it doesn't. But that is not covered under this act. So that is a gray area, which needs to be understood. Like what can be done in that scenario. That is not covered as such. The other aspect is about mentally retarded people. Like there has been a call by a section that said that, look, there are people in this in our society who by age, as per record, they might be like say 35, 40, but mentally they are below 18. Mentally they are like children. And if something happens to them, they are also vulnerable section. If something happens to them, some sexual offenses committed against them, should not they be also included within the ambit of Pocso? Now, this was something which was discussed before the Honorable Supreme Court also recently. But eventually, not recently, sometime back, the court has taken the view that, okay, there's an age which is stipulated. And rest, whatever changes has to be brought about, let the policy makers decide about it. Whether or not the mental age or the mental state of mind should also be considered and included within the ambit of Pocso. So those are certain things which still, therefore, more refined, a little more of amendments are required probably, and there is a scope for more refining of this act in future. So those are the things which I felt I should share as far as the challenges are concerned. There can be many more legal experts. There are people with different views. This is just my view. If you ask somebody else, next wise another lawyer, he will give it another perspective, a totally different perspective to this whole issue. And challenges could also increase, maybe decrease. But these are just my personal views. So this is what I have to share with all of you. And I think, I don't know, I've not covered the entire act, and I won't vouch. I won't say that I have covered everything, but an overview, a broad overview is what I try to give to all of you. And my suggestion to all of you is also this, that you all need to spread this to children, to people whom you know in your societies about this act. There's a duty also on the state to make people aware of this act. So I don't know how much are we publicizing it, but still it's important. So these kind of webinars are helpful, and I have to appreciate Ncdc as well as Strawberry Circle for taking this initiative, that they wanted to conduct a webinar on this particular issue. So it's important that we give awareness to children about this. I think some schools are doing it. Some schools, institutions have a big role in this. Schools have a big role in this. Schools should conduct webinars. Schools should conduct training programs where they are making their children aware of this. The counselors in schools should have knowledge about this act, and at least not in detail, at least broad overview they should have. And they should give this. They should give a message to children that to come forward and tell, and not keep it in their minds or hearts about offense committed against them. They should openly tell them. So that kind of trust also we need to develop. Whoever is dealing with children, they should develop a trust with children and tell them that, look, we are there for you. There are laws are there for you. You should come forward and explain your problem, and we can take the further legal remedy which is available. We'll take the further legal recourse. So this is what I want to just say in the end. And I have to thank all of you for listening to me patiently. I hope I've done justice, and thank you so much for your time and participation.
Thank you so much, sir. The last part which you told is very correct. In nowadays, the primary class sections are giving such a knowledge to the children, bad touch and good touch. They are teaching the children where they need to say no to others when they are doing such things. I mean, sexual harassments and all when they are doing. The teachers are showing it with demos and all, with a toy or with a, we can say, with a puppet and all, they are doing it. So nowadays it started to teach, because nowadays these things are increasing in our societies. So as you told, now they are giving more importance to these also. As a part of academic studies, they are giving these knowledge also to children. So that is good.
That's good, ma'am. Good to know that, ma'am.
Yes, sir.
That changes are happening in our schools.
And sir, many of them requested, sir, if you're stopping the screen sharing part, many of them requested to get the PPT also. As they were saying, it is very like.
Absolutely, and I have no problem. I'm more than happy to share it. But ma'am, please tell them that this PPT doesn't cover everything. It doesn't have the entire details of the act, but it just gives a broad overview. So they should also refer the act. They should check the act also from Google, and PPT of the act is available. All the acts are available. Bare acts are there. So whichever act we want to, it will be there. But some key ideas you will get from this PPT. So I can share this. I have no problem.
Yes, sir. Thank you so much.
Thank you, sir.
That will be so nice. And I think, sir, we can have a small section, like if they wanted to ask you anything that they can ask. So it will be more interactive section.
Absolutely, I have no problem. If you have time, if I have not exceeded time and the people are interested,
we can give some 10 minutes for clearing that
out. They have time, then they can ask me. Whatever little I know, I have no problem sharing it.
Yes. Someone dears, if you have any doubts, don't hesitate. Please come forward.
If anyone want to ask anything, you can directly talk with sir, so you'll get more information about any points which you need to get more clarity. So does anyone want to talk, please?
Yes.
The name Ravana, I don't know what is the exact name. Sir, please.
Sorry, my name is Shweta.
Shweta ma'am, yes, okay ma'am, please.
Good evening, sir. It was a very grateful session because such kind of information is very much needed in our society, because I think 5 out of 10 children faces such kind of abuse every day. Like, even I have also faced such kind of abuse in my childhood. But the problem in our society is how to deal with such people who says that the Kathua rape case was happened because there might be some fault in the girl or with her mother. How to deal with such people?
Thank you. That's a very good observation, ma'am, that you've made, ma'am, that with respect to Katwa, what you have said. And somewhere goes down to the mindset of our people. I mean, a lot of people. I will not say that everybody, but yeah, a large section is there in our society who think in a very, very, even today, in a very parochial, in a very regressive kind of thinking people have. And that needs to change, but it's not it cannot happen in one night, as we know. It is a very tedious task, and even after so many years of independence, I mean, we are still struggling with so many basic issues, and this is a very, very core issue, that how we need to understand gender-related issues, gender-related problems are there, and as well as child-related issues. Finally, in 2012, that we've come with an act. So you can imagine that we are taking it's taken time, but hopefully more and more awareness has to be given. That's very, very important. I think from organizations like NGOs which are there, as well as the state. The state obviously has to have a very, very important role. They have to direct schools to organize more and more awareness camps. Schools, not just schools, but other all the stakeholders, police department have a very, very important role. They have to be more. They have to show an approach that they are very child friendly, as well as you have commissions. The National Child Protection Commission and NCPCR is there. In every state there is a child protection commission which is there, protection of which basically talks which deals with protection of child rights. So these organizations which are there, then there is a separate ministry itself, Ministry of Women and Child Development is there. So we have got so many agencies which are there. National Commission for Women is there. So now we have to somewhere now the message has to be given strongly to across the board to people at large, that what are the implications of these kind when you do an offense like this, and the implications of the act, and also we need to tell them about this act, which is this act also itself says that the state is duty bound to spread awareness about this act. So I think more it is done, the better it will do. At least that's what I feel.
Sir, I think Shweta ma'am has asked a question like, what is the maximum time span or period a victim can lodge a complaint after the incident?
There is no specific time as such. If a victim has faced an offense, she's gone through a traumatic experience, and which comes within the ambit of the offense, she has to inform to her if she cannot do it, he or she cannot do it herself by himself. The parents have to inform. That's how it is. So at the earliest, what do you mean by FIR is first information report, and that has to be done at the earliest. But as I said, there was an instance where I had pointed out in my slide also. It was a case where there was a delay, and this was before Pocso had actually was enacted. So that delay was condoned. It was a case of a rape of a minor girl. So courts will take a lenient view in this scenario if there is even if a delay, but if a minor is coming forward and making an accusation that okay, they have gone through something like this. But it is always advisable to immediately inform the police, the authority, either the child protection helpline or the police.
Radha ma'am, I hope it's clear for you.
Yeah.
Okay.
Thank you.
Okay, does anyone have any doubts? Please come forward. And in 5 minutes, we'll be winding up the section. So, I think they have cleared, and we are getting a good response. Mostly, they were asking for your PPT presentation. So they feels like it was having a lot of yeah. Shweta ma'am.
Hello.
Our chat box.
Hello.
Yes, ma'am. Please.
Hello.
Please ask.
Yes, we can hear.
Yeah, I am asking a question here. Thing is that you mentioned about sacrosanct relationship. What about like you refer to? I mean, the family itself, family, parents, or someone. But what about professional relationship? In the sense, if I go to a doctor, or if I go to an professional helper like police, or else because there are chances that many Dalit women, Dalit minor girls, who have been sexually abused, who cannot lodge a complaint due to because of their low position in the social strata also. They don't have social agency, so they are helpless. So does sacrosanct relationship also I mean the term also include this kind of relationship in the sense like professional help?
Thank you for the question. It's a good question. I did touch it, but I think I didn't elaborate it too much. I think it's it's a good question. It absolutely, because and that is even whoever is like in a position beyond fiduciary, beyond like whoever is in a position of authority, for example, a police officer, a person in the armed forces, or whoever it is, and a medical professional, if they misuse their position, and if they misuse the trust which is there, which a child has in them, because these are places where somebody has gone there to report an offense, and this happens, which actually happened in the case of Mathura rape case that we talked about, 1978. This happened, and then there was a huge UN cry, and therefore, specifically these act mentioned Section 5 as well as Section 9, and wherever the aggravated, you'll find that aggravated penetrative offense or those kind of aggravated sexual assault, when it's mentioned, they have specifically mentioned all these categories, including police officers, including the people in high positions, schools, institutions, principal, teachers, anybody who is in a position, in a fiduciary position, in a position of trust, who builds trust on with the child and then misuses it. A child can go against them. They can file complaint against them. And in the case now, if a child cannot go, the victim cannot go, then there are areas where people are there to help them out. It's just that we need to, somebody will have to be there at the side of the child. If the parents are not there, then the guardian, somebody should direct the child. You have the child helpline numbers, you have child welfare committees which are there, and then there are NGOs, various NGOs are there. So they will help. And then there are numbers of experts, there are numbers of counselors which are there with the child welfare committees. In each district, there should be a child welfare committee. So they are mandated to keep a register with all the details of counselors and experts with them. So if you call them, they will also help. So it is just a matter of just guiding. Somebody will have to anyhow will have to show them the right, just show them the path. So anybody can do that.
Okay, thank you so much. Just an extension, small extension of the previous question I had asked. So in terms of like, I mean, you may be well aware of the Athras rape case which happened in the last September 2020.
Yes.
Where the victim was a Dalit girl, and it has happened almost, I mean, close to the capital of India, New Delhi. So, so in that, we have so stringent law which supports the victim or whatever, whomever. But what is the position of the lower strata of the woman? Yes, justice is given to who can afford it, or who have the access to the network or whatever, in the whatever form, in the NGOs or whatever. But in broad daylight or broad day, things are going up and burying up bodies. So in spite of laws, Dalit woman body, a minor, not even a woman, a girl, has been buried at midnight, 2 o'clock. So, I mean, what is the future course of the law should be? Should there be an extra body which an extended hand? Do you see there's the way to go to act on situations from lower state of who belong to such as Dalits and tribals?
See, again, it's a good case that you pointed out, Hathras. See, that's in a case again which shocked the conscience of people at large, nation at large. we know that, see, SC/STs and the other vulnerable communities, the marginalized communities, there is a special ministry as well, which is there for SC/STs and tribals. There is a commission which is there, which functions for the backward classes and the SC/STs, which is there, as well as we do. So there is no dearth of commissions and bodies right now. For each of these vulnerable sections, we do have. But what is the need of the hour is that they realize that their powers and they function immediately when we see something, and stringent action and timely action happens, because only then that will be a deterrent for others, and people who have this kind of mindset will stop doing it. So that is the problem. So like what has happened with Hathras, and the media attention is not a good thing. So the attention of media, and then so we need to have speedy trial. Like the fast track courts are there after the Nirbhaya case. The fast track courts are there. So the point is that the system and all the stakeholders have to become more aware of their and need to be more stringent in their approach, and they have to take fastidious, quick action. The response has to be quick against the offenders, and because the idea that we will be able to escape and all of that if we are influential, that needs to that message has to be given that it's not possible. So it has to be that everybody has to be, those involved will have to work for speedy trial. And there is also provision, just to add on to what I've just said, that as far as if somebody is deprived of a legal aid, they can approach the legal service authority. Like for example, in Delhi, we have DLSA, Delhi Legal Service Authority. Likewise, there is a Legal Service Authority Act is there. So which provides legal aid, free legal aid to those who are below poverty line, or those who cannot afford legal aid. So those people can approach those concerned authorities, and they will get proper legal aid. That's also there. Free legal aid.
Yes. As we are having time limit, yeah. Can we wind up the section, sir? We are having a time limit also. It is going to wind up.
Yes, ma'am. Yes.
So with this sections,
yes, we can wind up this section with our vote of thanks. For that, I'm inviting Premila ma'am for doing the vote of thanks.
And sir, if we are ready, that if they want, like we can have a second part of section of this webinar. If more points and all we can include, and we can have a small other section also, second part of the webinar, if they are requesting to.
That's for doing the chat box and all.
Yes.
We can think about it, ma'am. Maybe some areas which you've not covered in the recent cases and
yes.
On the recent judgments of Pocso, we can think.
Yes. So that will be kind.
We can have a session. Yes. Recent judgments of Pocso.
Thank you, sir.
Thank you. Premila ma'am.
Yes. Thank you so much, Renu ma'am. So let me thank our honorable guest, Advocate Robin Raju sir, for coming over here and from attending, giving us such a wonderful speech about that legal informations and all. And yes, sir, as Rahmat ma'am said, we are eagerly waiting for another one more session of you. So we'll be able to clear lots and lots of our doubts. So thank you so much, sir, for coming over here and spending your valuable time over here. And yes, then I would like to thank our senior faculties, our Rahmat ma'am, our Anujam ma'am, Shiba ma'am, and Smita ma'am, and my co-faculties, Renu ma'am, Arati ma'am, Lekha ma'am, and yes, and all each and every one who had been here and who had participated in this webinar. Thank you each and everyone for making this program a wonderful success. Thank you.
Thank you so much, ma'am. And once again, sir, thanking from our part and from all the faculties and all participants part, I am thanking you for spending the valuable time with us.
Yes.
Thank you.
Thank you.
So
sir.
thank you, everyone.
Pleasure.
Thank you, sir.
Thank you, sir.